Good morning to everyone. I'm Harvey J. I'm the presiding judge today. I'm joined by two of my very esteemed colleagues, Judge Jim Edwards and Judge John Harris. We're here on case number 2024-3311, City of Ocala versus Board of Trustees, City of Ocala Firefighters Retirement Plan and Professional Firefighters of Ocala, IAFF Local 2135. Obviously, this is a Zoom OA. If everyone would be mindful of that, the vagaries of the Zoom format, it would assist us in hearing you. If perhaps you would turn off your microphone if you're not speaking, I think that would help the quality of not only the recording, but also our ability to interact with you. If you would also be kind enough to let us finish any questions we have for you, that would also be helpful. Obviously, that's an important part of the OA process. Mr. Thomas, I believe you're here on behalf of the appellant.
That's correct. The City of Ocala.
Would you like to reserve any time for rebuttal?
5, please, Your Honor.
All right. So noted. For the record, you may proceed when you're ready.
Thank you. May it please the court. Again, I'm Glenn Thomas on behalf of the City of Ocala. Briefly, the posture of this case is this is an appeal by the city from an order granting summary judgment in a declaratory judgment action by the Board of Trustees that was joined by the Firefighters Union. The topic of the case is the Ocala Firefighter Plan and whether a 2011 law restricting what is included in pension benefits applies to the plan.
Excuse me, counsel.
Yes.
What we're dealing with here is whether or not Component A firefighters are subject to a cap of 300 hours of overtime, correct?
Correct.
And in order to know that, we need to know whether Ocala's plan was a supplemental plan, correct?
That is correct.
And what's the critical date for when Ocala's retirement plan for firefighters had to be a supplemental plan?
It had to be a supplemental plan on December 1st, 2000.
And why is that?
In Chapter 175, there is a provision, and it was the language was actually adopted in 1999 as part of a bigger overhaul of Chapters 175 and 185, which govern police and fire pension plans for those cities that wish to participate and receive distributions. Now, one of the things that happened in that was they limited how a city could use premium tax revenues in that 99 law. Cities could no longer just use all the premium tax revenues to offset their contributions. They had to use future premium tax revenues to fund extra benefits. Now, not every city was using those premium tax revenues to offset contributions. Some of those cities were putting them into a separate plan, a separate supplemental plan where all of the premium tax revenues went in there and they were used to fund firefighter benefits. So 99-1 included an exemption for cities that had supplemental plans at that time, and they exempted them from the minimum benefit of what is considered compensation for pension purposes. So that was the point of that exemption, was to exempt those supplemental plans, because those cities weren't using all their premium tax revenues to offset their contributions. They allowed those cities that had a supplemental plan at that time they weren't required to comply with this new minimum benefit. And that December 1st, 2000 is just the date they chose for the plan to be in place.
Okay, Mr. Thomas, let me interrupt you one more time here. under 175, 351, I think is it 4A? The, says notwithstanding any other provision with respect to supplemental plan municipality, a local law plan and a supplemental plan may continue to use their definition of compensation or salary in existence on March 12, 1999. Now, back on March 12, 1999, Ocala's definition of compensation was full compensation, everything, there was no cap, correct?
Well, that is correct.
And how does this play in then with the March 12, 1999 date in terms of the definition of compensation versus the December 1 date?
Well, the March 12th date wouldn't matter if the December 1st date didn't apply. In other words, if the city didn't have a supplemental plan on December 1st, 2000, we don't even get to the March 12th date. But March 12th is 1999 was the day that 99-1, the law was signed into law. That was the effective date. However, it's been the city's argument entirely all along that wouldn't apply to the city, because in September of 2000, the city abolished its firefighter supplemental plan. Now, at that time, before September, the city's firefighters were participating in the general employees plan. The general employees plan could not receive premium tax revenues because those had to be put in a firefighter plan. So the city had a separate supplemental plan set up, and all of the premium tax revenues went into that supplemental plan for the funding of firefighter benefits. So in September of 2000, the city adopted Ordinance 3088. And what that ordinance did was, and we can look at the language in the ordinance and see, it abolished the supplemental plan. It says that in the title. It also repealed, it says it repealed the ordinance for the supplemental plan in its entirety, and they established a local law plan. So they took the firefighters out of the general plan and gave them a local law plan under Chapter 175. But the plan that is attached to 3088, if we look at it, there's clearly no separate component. There's no supplemental plan. All of the premium tax revenues are used to fund that plan. They go into the plan just like any other contribution. And one of the hallmarks, we know whether there's a supplemental plan or not because it's identifiable. There has to be a separate identifiable plan, a separate component within the local law plan, and into which all premium tax revenues go for the firefighter extra benefits. And this is where I've cited to the DMS versus Delray Beach case, and I've been told consistently that it's not helpful to my case. I think it's helpful for determining what a supplemental plan is, how we know there's one. But more importantly, I think it's important for determining what a supplemental plan isn't. And in that case, that was largely an impairment of contract case, but one of the other issues, a separate issue, was the city of Delray Beach was claiming an exemption from the minimum benefit in a similar situation. In that they were claiming that the exemption allowed them not to have the minimum benefit for compensation. And what the court said was, in this case, they said the city can do two things. They can place their premium tax revenues into the plan and use for plan funding for minimum and extra benefits, or they can place it in a separate supplemental plan to pay for extra benefits. And the court pointed out that there's nothing in the record that shows there is a separate plan was maintained, a separate supplemental plan was maintained in conjunction with their plan. That's essentially the situation we have here. When 3088 was passed by the city, there was nothing in that new plan that was adopted that showed a separate supplemental plan component into which the premium tax went to pay for extra benefits. All of the premium tax revenues went into the plan to be used for plan funding. Now, if there wasn't a supplemental plan on December 1st, 2000, which Ordinance 3088 appears to demonstrate, then the city was not a supplemental plan municipality, and the entire exemption wouldn't apply. Honestly,
Counsel,
I don't.
Counsel, excuse me. Doesn't 3088 talk about it merges and consolidates the old plan into the new plan?
It does, and the
What does
reason,
that mean?
well, that's going to be required. So you already had retirees. There were liabilities. There were assets in that plan. There was a board of trustees that was governing that plan in compliance with Chapter 175. All of those things were transferred into the new local law plan. And now they had to continue paying benefits, and they had to keep any accrued benefits. That's just the law. You can't reduce a benefit that somebody already has a right to. And so what happened there was what the law requires. All the assets, liabilities, the board of trustees, they were all transferred over. But what that means is the supplemental plan was no longer a supplemental plan.
Counsel, I'm sorry, one more time here. I know you don't like them, but there were several documents offered into evidence by the pension board and or by the firefighters local in which the state of Florida declared or listed Ocala's retirement fund as a supplemental fund after December 1 of 2020, correct? I'm sorry, of 2000.
I have seen the chart that says that, and I'm not really sure why that would still show up there.
Well, those charts were, Counsel, those charts were filed in advance of the summary judgment motion hearing, correct?
Yes, they were.
And you didn't offer any evidence to oppose or to point out what you say is the inaccuracy of any of those documents that described Ocala's retirement fund as a supplemental plan, did you?
Well, it's harder to establish the non-existence of something. I believe 3088 does exactly that.
My question was, you didn't offer any kind of evidence, you didn't depose anybody, nothing to prove that those documents were wrong, did you?
No, I did not submit anything, no.
And you agreed in your cross motion for summary judgment that there were no disputed issues of material fact, correct?
I qualified that. I've always maintained that there are disputes as to the factual issues that would support a decision regarding whether there is a supplemental plan, whether they were a supplemental plan municipality. I've always suggested there isn't a disputed issue of fact for two reasons. Number one, I don't believe there is that the language in 175.351(4)(a) would exempt anyone from the 2011 legislation. So it doesn't apply. I don't think it creates an exemption. I think the language in Part 7 of Chapter 112 is clear that those are minimum standards that govern, and there is no exemptions from it. And if there is an exemption, it is an exemption from a minimum benefit, not a maximum benefit. It was never intended to exempt those plans from the minimum benefit or the minimum standards for operation that apply to all government plans under Part 7 of Chapter 112. But I've also noted that in the affidavits that were submitted from the Division of Retirement, there's nothing in there that states the city was a supplemental plan municipality. As a matter of fact, I think the only thing, the first chart that was submitted with the 2011 letter, that doesn't even apply. Those
Mr. Thomas, let me ask you about that. Do you have a quibble argument against the affidavits themselves legally, or is your problem that they don't say what the other side claims they say, or a little of both?
Well, I think I mean, the affidavits from the state, I think what they do is they authenticate public records.
Which is perfectly permissible. You would agree with that, correct?
I don't have an issue with that. We would have conceded that they were actual public records. My problem is there's nothing in there that says they're accurate.
Well, did you, and maybe you've already answered this question from Judge Edwards, but you didn't present anything to the contrary, correct?
Well, I believe Ordinance 3088 addressed it even better, because what it did was show that the actual plan that was in place on December 1st, 2000, and showed there was no supplemental plan, which to me, that established more than a chart that that there's no real evidence has been updated regularly, or it's just basically that chart is just an attachment that just rolls over from year to year. I thought that the actual ordinance and the actual plan showing there was no longer a supplemental plan was the stronger of those two.
Mr. Thomas, you're into your rebuttal time.
Okay, I'll go ahead and turn it over.
All right, thank you, sir. Ms. Greenwood, are you prepared to present on behalf of the appellees?
I am, Your Honor.
All right, please proceed.
Thank you. May it please the court again, Blanca Greenwood on behalf of the Board of Trustees for the Ocala Firefighters Retirement Plan. Your Honor, let me just answer one question that I believe Judge Edwards had asked with regard to the December 1st, 2000. That can be found in Chapter 175.032, subsection 25, which gives the date December 1st, 2000. And it says supplemental plan municipality means a local law municipality in which any supplemental plan existed as of December 1st, 2000. Our contention as presented through our filings and through the affidavits that have been spoken about is that a supplemental plan did exist in December 1st, 2000. The Ordinance 3088, if you read it, clear language states it was a consolidation of the firefighters' supplemental pension fund with the City of Ocala Employees Retirement Plan. Also, clear language in Section 4 of Ordinance 38 states that there's to be no diminution or alteration of benefits. In other words, what they did is they consolidated and merged.
Counsel, as far as the no diminution, wasn't that as the people who were already retired and their surviving beneficiaries? I mean, in Section 4 itself.
Yes, it did include people that had retired, but also there's to be no diminution of benefits. I think it's clear also if you look at the ordinance as it exists today, sections 43, 44 of the city ordinance does allow for supplemental benefits. In other words, they're using the state monies also to fund for the COLA, the cost of living increases. In addition to that, Your Honor, if counsel argued that it had to be a separate plan in order to be a supplemental plan. But if you look at the definition of supplemental plan in subsection 24 of 175.032, it means a plan to which deposits are made to provide special benefits for firefighters, or for firefighters and police officers if both are included. Such a plan is an element of a local law plan and exists in conjunction with the defined benefit plan. I think this case, Your Honor, boils down to just a plain reading of the language in the ordinance and in the state statutes. I believe that the notwithstanding any other provision found in Chapter 175 applies to the Ocala firefighter plan. There's no evidence or argument from counsel that was presented or has been presented that refutes the affidavits or the public records that have been presented in this case.
Okay,
And-
let me interrupt you for just a second here. So what you're saying is that because part of the insurance policy premiums, the money that Ocala receives is used for COLA, that's the extra benefit or the supplemental benefit that the firefighters receive that then qualify the plan as supplemental?
Yes, Your Honor.
And again, where's the COLA benefit found?
That is found in the local ordinance in section 4345.
Okay. And that existed back as of December 1, 2000?
Correct, Your Honor. I believe so. Yes.
Go ahead. Thank you.
Thank you, Your Honor. This case, there is no dispute that Ocala was a supplemental plan in March of 1999. There's no dispute that the definition that was used in March of 99 included no cap on overtime. There is equally no dispute that Ordinance 3088 captured what the previous plan provided for, which was found in Ordinance 2891, and is now encoded in the municipal ordinance sections 4340 on. In the lower court proceeding, there was no evidence presented to the contrary. Plain reading of the statutes, plain reading of the ordinance carves out an exemption from the 300-hour overtime. And in fact, that's in line with what you see in the plan today, where the city carved out, as previously mentioned, a component A firefighters with no cap and a component B firefighter with the 300-hour cap. I think to argue that it doesn't apply kind of begs the question, then why are we creating two different components of firefighters in the current ordinance? For all these reasons, Your Honor, and for the reasons as laid out in our pleadings and in our briefs, we ask that the court affirm the lower court's decision. Thank you.
Thank you, Ms. Greenwood. Rebuttal, Mr. Thomas?
I'm sorry, that was for me? I
Correct. I believe she's completed her argument, and so time for your rebuttal.
Yeah, there's a couple things I just wanted to point out, and one of them is as you mentioned about the diminution of benefits, that these benefits were vested, and so they couldn't have been reduced due to the creation of a new plan. That's just per the law. As far as the using the premium tax revenues for benefits, that's essentially what every local law plan did, and I think that's kind of what the Delray Beach case says. It's not enough to just use those premium tax revenues and put them in the plan and use them for benefits. That's what every plan does. There has to be a separate component of the plan into which all of those premium tax revenues are placed. If you're using it to fund the COLA or you're using it to fund another benefit, that is essentially just offsetting the city's contributions, and that means that's not a supplemental plan. And I'm all for. I agree with the whole plain reading. I don't think there's any more plain reading than the part of in Part 7, Chapter 112 that says in the event of a conflict, the minimum benefits or the minimum standards under Part 7 are governed. And I don't think there was any intent when in 1999 the legislature passed an exemption for supplemental plans from compliance with a minimum benefit, that they intended to exempt those same plans from any future changes to 112 that provide minimum standards for the operation of a public pension plan. I also would point out that, yeah, I know there's been an argument that pension statutes should be construed liberally in favor of members and their beneficiaries and benefits. But I think there's the law. It also says that in the case of an exception, exceptions to laws would be interpreted narrowly, and they'd be construed against the person attempting to take advantage of the exception. As far as the dispute, that it was brought up that there's no dispute that the plan was in place on March 1999. Again, that date for our purposes is largely irrelevant, because the date we need to look at is what was in place on December 1st, 2000. And I think Ordinance 3088 clearly shows that there was no supplemental plan for firefighters on that date. And again,
Ms. Greenwood asked a question that I don't think has been covered yet. Why does the ordinance, or why did it create two different categories of firefighters?
That was actually much later. That was in, I believe, 2016, where they created different tiers. At the time, they were looking at a lower benefit level for future firefighters, so that current firefighters didn't have could keep their benefits accruing at the same rate. In other words, there was no reduction when they were collective bargaining. They agreed to no reduction for current firefighters. They only applied the
300-hour cap only applied to the component B firefighters, and that's the way the ordinance still reads.
Right. That is correct.
Council, isn't that some evidence then that the city was continuing to use the old definition of compensation, at least for component A firefighters?
I don't believe the city understood at that time. I mean,
whether they understood it or not, they were continuing to use their old definition of compensation for component A firefighters, correct?
Yes, they were.
And do you think the trial court should have ignored that and all the other documents that basically were consistent with this being a supplemental plan that used the old definition of compensation, at least for component A firefighters?
Well, if it comes down to statutory interpretation, I don't think it was important for determining many of the issues in this case as far as the application of an exception.
Okay, thank you.
Mr. Thomas, we have finished with your time, but because part of that was in answer to questions, I'll give you another 15, 20 seconds if you want to close up anything that you haven't said.
Thank you. I'll just close in saying that I believe that the language clearly wasn't intended to be an exception. The language under 175 wasn't intended to ever exempt plans from Part 7 of Chapter 112. And I would just ask the court to respectfully overturn the decision below.
Thank you, Mr. Thomas. Thank you, Ms. Greenwood. That will be the end of our oral argument this morning, and we will officially be in recess. Thank you all.
Thank you, Your Honor.